Hello and welcome to the Tennessee Informer. Thank you all for joining us tonight. Our guest tonight is William J. Watkins Jr., a research fellow with the Independent Institute. He is the author of several great books, including Crossroads for Liberty, Recovering the Anti-Federalist Values of America's First Constitution. He received his B.A. in History in German, summa cum laude, from Clemson University, and his J.D. cum laude from the University of South Carolina School of Law, and his LL.M. with merit from the University of London. He's a former law clerk to Judge William B. Traxler, Jr. of the U.S. Court of Appeals for the Fourth Circuit, and is president of the Greenville, South Carolina Lawyers Chapter of the Federalist Society. He has served as a prosecutor, a defense lawyer, and has practiced in various state and federal courts. Hey, thanks so much for coming on to the show tonight and for all of your efforts in defending a proper interpretation of the Constitution.
Well, Dave, thanks. I really appreciate you having me. I've been looking forward to this since I got the invite from you.
And well, I have too, and I'm glad that you were willing and able to make time. Let's talk a little bit about your book, Crossroads. You're author of several other books, but Crossroads I just finished reading. It's a great book with important information that I think everyone, especially state legislators, should read. And let's talk a little bit about the difference between what was ratified versus what we allow today.
No, absolutely. That's a good starting point. You know, with this book here, I tried to look, essentially, we've got well over 237 years, I think it is now, of history between ratification and where we are. We've got clear arguments by the Federalists and the Anti-Federalists on what they claim the document would do. And I looked at that track record and came to a conclusion that, well, these anti-federalists, they were spot on in many ways about how various provisions of the Constitution would be abused and would be ripped from the written text, from the mooring, if you will, in order to expand government. And I go through multiple provisions where there were substantial arguments from both sides, and the anti-federalists hold the field when you look at where we are today.
Yeah, absolutely. Who was right? Well, the anti-federalists, unfortunately, were right. Most people have heard of the Federalist Papers, whether they have read them or not. And of course, the Federalist Papers were not only intended to explain how the Constitution was supposed to work, but it was also intended to answer those objections by the Anti-Federalists, which, as you know and you can elaborate on, the Anti-Federalists was kind of a misnomer. They were not, that was a name given to them by their political opponents, the Federalists. But they were spot on. And the explanations in the Federalist Papers were pretty convincing. That, hey, this is not how it'll happen. And of course, Hamilton and some of the others tried to make it sound as if the concerns of the Anti-Federalists on things like the Necessary and Proper Clause, General Welfare Clause, Supremacy Clause, and others, basically, well, that'll never happen. You're being irrational for even bringing that up.
That's right. They said, this is silly what you're arguing. This is hardly merits a response. And it did receive a response, and let's face it, Madison, Hamilton, Jay, these are intellectual heavyweights of the founding era that brought their full faculties to bear on these arguments. And again, you just read the Federalist Papers, the arguments are logical, they seem convincing till you put them side by side with the anti-federalist argument and what has happened. How, for example, Madison criticized the anti-federalists for believing that the General Welfare Clause in Article 1, Section 8 would lead the federal government to having the power to spend and exercise powers for whatever it believed was conducive for the good of the country. Madison points out how that language was really copied from the Articles, and no one claimed the Confederation Congress had such a power. But lo and behold, part of it didn't happen until the 1930s and the New Deal, when the Supreme Court finally said, yeah, we've looked at the various arguments, and it does confer a general power to spend money for unenumerated purposes, so Congress can beat the states up with federal funds if they don't do as Congress dictates. So the Anti-Federalists in that example and many others, though it might have taken a while, sometimes it didn't take long, but they were right.
Yeah. Well, we hear the phrase "we the people," and that was even an issue of concern. I know it was brought up in the Virginia ratification debate, and Patrick Henry asked, what's this "we the people"? We're a federal republic. Are you guys trying to pass create a nation, create one nation? Is this a national government? And then, of course, the explanation was, we the people organized the states. But once they got in power, not so much Madison, but Hamilton and others, and Marshall, I think, used that argument of "we the people" to sell it as a one consolidated government rather than a federal republic.
No, that's right. Marshall, James Wilson would be another example. Hamilton, sort of like compact. We don't see the least trace of a compact in this instrument. What are you talking about? When you could even go back to remarks by very conservative Federalists, Gouverneur Morris, for example, who continually referred to the Constitution as a compact, but rather what people call it. You look at how it was ratified, separate state ratification conventions, with the idea that if not all 13 ratified, certain states would stay out of the Union because there was no body known as the American people. It was the people of the several states. Of course, North Carolina and Rhode Island, when George Washington swore his oath and opened the new government, weren't part of the Union. Because they were a bit nervous with no Bill of Rights to clarify certain expansive provisions of the Constitution, and they held out till they saw that there was going to be change that they could stomach.
Well, and even after the Bill of Rights, which we ended up with 10, but in your book you talk about over 200 being recommended by the different states. Not that we would expect necessarily that many would get through, but you would think out of 200 we'd get more than 10. And do you want to talk about maybe a few of those that we'd have been much better off with had they adopted them?
Sure. One thing we have to remember is, though we have this almost cultic worship of the American Bill of Rights, first of all, nobody really referred to it as the Bill of Rights in the founding generation. It was just the amendments to the Constitution. And really, the Bill of Rights was, we're going to do just enough, the Federalists said, so we can claim that we've acted in good faith to all these opponents and added some security for them, when really this isn't going to do anything to change the system of government. I believe Hamilton himself admitted that, hey, if you were against the Constitution before the Bill of Rights, there's not a single thing in these 12 proposed amendments, 10 of which were quickly ratified, that's going to change your mind. There were a number of provisions we would be much better off with. For example, requiring either supermajorities in Congress to borrow funds rather than letting Congress just spend, borrow with majority votes. There's also hopes of reviving the old requisition system that, let Congress ask the states for money. The states can tax the people as they see fit. And if the states don't come through, then Congress you can directly tax, but you have the states as intermediary bodies between their people's pocketbooks and the national government. That's another good example of something that we certainly could use today.
Oh, yeah. And representation was another issue. They really felt like what we're especially based on our population today, really don't have enough people up there to reasonably represent the size of our population, even though you have to cap it at some point. But we could certainly have more people up there representing the 300 some million, assuming those are all citizens, so 300 some million that we have in the country.
Yeah, small was beautiful to the Anti-Federalists. They, from the get-go, thought that a continental republic would just be ungovernable except with a centralized power that could push toward tyranny. Because of the scale of the country. They thought that true self-government could best be practiced in local units close to the people, where the people could participate, where the people could have direct contact with their legislators, whether it be they go to church together, they go to the market together, or the representative, say, practices law in the town and the people are his clients. They mingle. The representative has the sense and the feelings of the people, which is not possible today when I believe the average congressional district is about 750, 760,000 people for one representative. There's no way the people can know their representatives, and the representative will mingle and know the hearts and conditions of the people. Even Washington was concerned, high Federalist that he was, about the representation scheme in the Constitution. All the Federalists really would have agreed that you should have smaller districts, and one of the arguments they pulled out, well, they don't need to be as small as state districts because Congress is only going to consider war, foreign policy, maybe some international trade agreements. Right. And that's it. So they don't really need to know all this local information. So we can have a little bit bigger district. But even the Federalists would never have imagined that we call representation 1 for 750,000. That's way out of bounds.
And they were for term limits as well, which a lot of people support today.
Yeah, unfortunately, the Supreme Court killed that idea in U.S. term limits versus Thornton back in, I believe, 96 was the year. But yeah, the Articles of Confederation, for example, had what they referred to as rotation in office, what we call term limits. Anti-Federalists were strong believers that you should have fresh blood in office. They worried that there would be an aristocracy formed if folks were just continued in office and got too comfortable up at the central government. So that was a main thrust for amendments as well, but that was unfortunately rejected by Madison and his colleagues when they framed our first 10 amendments.
Well, even with the 10 amendments, and specifically the 10th Amendment, for the Constitution to work the way it was sold and the way it was understood and ratified, regardless of the time frame, that would require the states to really be paying attention and engaged and involved. And that really has not happened, certainly hasn't happened in the last several decades. But I think even with all the warts, if we had that, and certainly if we'd had that since the end of the Civil War, we'd be a whole lot better off. It would never work without the states just focused on keeping the federal government in its lane.
No, that's part, Madison in Federalist 51, I believe it was, talks about the horizontal and vertical checks and balances there and restraints on power. And of course, when we look at the horizontal in the federal government, that's just, we have 3 branches. Well, actually, we have 4 today, but in the framers' design, legislative, judicial, executive. And then you have your vertical with states and national government, where, of course, power is similarly divided in the states. But Madison specifically says that the states and national government will check each other. And that implies the states paying attention. That implies that they have some power to not just protest, but act against federal measures. And I think Madison's thought on this comes more to fruition, the Virginia resolutions and his report of 1800 with interposition. Of course, Jefferson advocated nullification in the draft of his Kentucky resolution, but both those gentlemen put teeth, if you will, to this idea of checking the national government. And you're right, Dave, we've lost that, at least since Appomattox. There has been no check.
Yeah. Well, I do want to get to the main topic tonight of the 14th Amendment. Before we go to that, any closing remarks or last thoughts on that issue as far as the convention goes and in your book, The Crossroads of Liberty?
Just one thing I would say is, though the Anti-Federalists, we both agree, were right, nonetheless, as I believe your words were, as how the Federalists, quote, sold, end quote, the Constitution to the people, that's how we interpret it, not necessarily the arguments against it, even though the Anti-Federalists proved to be correct in many regards. But what did the Federalists say in response? How did they promise that it would be interpreted there? How was it sold to the people? And it was sold to the people as a document of few and defined powers that should be construed strictly against the national government. Unfortunately, since early on, the Federalists have been trying to distance themselves from those representations and treat the Constitution as if it were something else than what they promised.
Well, and the more people that know, and that's why, like, I would recommend everybody read this book. You know, if you, by the way, it is a gold winner for political current events. If you don't have much background in this book, you could read this book and come away with a functional understanding of what was proposed and what we've allowed, put it that way. So I think it's a good book, and especially, you know, if nothing else, maybe get it for your legislator to read. Read it yourself and get it for your legislator, because it is an excellent book. I want to turn to a recent article you wrote. It's titled 14th Amendment. Is it time to topple the 14th Amendment? It was at the independentinstitute.org's website. And I like this article. I'm not a big fan of the fraudulent 14th. I agree 100%. I think that 14th, as currently utilized or distorted, has pretty much destroyed our Constitution to a great degree. And so let's talk about that article a little bit.
No, that article was sort of brought about by my just frustration. And for years, folks on the right have been trying to, in some senses, cabin the 14th Amendment to its original purposes. But it has the genie escaped that bottle so long ago. And now, as you mentioned, the 14th Amendment essentially is the Constitution. You can forget about the other provisions. Any big ticket case at the Supreme Court that the commentators follow that has a real impact on, Joe Sixpack in America is a 14th Amendment case there. It is the Constitution. And when you look at how far we've gone from the limited aims of the 14th Amendment, which we can talk about here in a bit, you just have to accept that we cannot chip away at this monster with interpretation. We have to just get at the heart. Is this ultra vires? Is this really part of the Constitution, or isn't it? Because if it is, we're in trouble. If it's not, we have a hope. If we reject it, even though we're late in the day, some would say the horse has left the barn. I still think we can wrangle the horse back to the barn. But though we're late in the day, we still can recover a federal system of government if we cast the 14th Amendment aside.
Well, if a lie does not become true with time, and and everything about the 14th, the way it's practiced today. Well, let's start with the fact that it was not properly ratified, and let's just kind of start there and what its original intent was, and then we can kind of take it from how they perverted it, and most of that perversion came decades later.
No, that's right. No, it wasn't properly ratified. We can go back and we can look and just simply count heads and see that you have several states pulled their ratifications before it was ultimately ratified. Even the Congress and its own declaration only lists 27 states as having ratified when 28 was the number required. And of course, a large number of those states had proverbial guns to their head, insofar as Congress had disenfranchised large portions of the population and told the states, hey, unless you ratify this, you're not back in the Union, and we're not going to let your representatives come to Congress and have any say in making laws that are going to govern you.
But you have to be a state to ratify, right? Don't you have to be a state to ratify a constitutional amendment?
I would argue you have to be. The radical Republicans were a little bit loosey-goosey on this. We all know that the stated aims of the Lincoln administration and most of the moderate North was to preserve the Union. Now, we can question whether a union held together by force is a good union or a bad union, but that was the aim. That Lincoln clearly says, hey, if I could save the Union and free all the slaves, I would. If I could save the Union and free no slave, I would. I want to save the Union. That's my primary goal here. So under the Lincoln theory and most of the moderate North, the states had never left the Union. Of course, the radicals come up with this state suicide theory, where the states are conquered provinces in the South and don't exist. But if we go with the mainline theory of the war, the states were always part of the Union, and actually the 13th Amendment was sent to all states for ratification, which was a signal from the administration and Congress that, hey, we're all back together, one big happy family. Well, maybe not happy, but we're back together. The southern states were asked for their ratifications, and of the number of states, I think at least 8 southern states were counted, former Confederate states, for the initial number of 27 at that time, for the passage of the 13th Amendment. So it appears southern states are restored. Well, not so fast. The radicals in Congress realize that if the South is restored, you have the 3/5 clause abrogated, right, with the 13th Amendment.
Right.
And therefore, Southern representation could increase in the national legislature, and that could inhibit Republican aims of the Republican Party. So Thaddeus Stevens said, whoa, stop this. We have to keep these states out of the Union till we establish the supremacy of the Republican Party. And of course, Stevens worked hard to do that by disenfranchising and imposing military rule under the Reconstruction Act upon the South. But again, the 14th Amendment, as you question, if they're not states, why are you sending it to them to ratify? And if you have to have a gun to their head, which literally was the case with Union troops, what value is the ratification? But bottom line, even if you consider when you look at all the irregularities, you still didn't hit the requisite number of 28 with the addition. I believe it was Nebraska had joined the Union at this time to up it from 27 to 28. That was required. Congress still didn't hit that number with their own count. And then you take away the southern states that are being forced to ratify, and it's just an ultra vires act. And this is not just a crazy theory that you and I have cooked up. For example, Forrest McDonald, he was the Ingersoll Prize winner, great historian from the University of Alabama, widely respected. He's written on this, and he says flatly, there's no way anyone can, with a straight face, argue that the 14th Amendment was properly ratified. Now, McDonald will cut the radical Republicans a little bit of slack on the proposal of it. In my article, I even question whether it was properly cleared the Congress and was sent to the states, because you have in the Senate, now it certainly passed the House with no problem, but in the Senate, it was falling short of being able to clear that body. And what the Republicans did is they got rid of John Stockton, a senator from New Jersey, by a majority vote, threw him out of his seat. Well, you can only, according to the Constitution, unseat or refuse to accept the credentials of a senator when he first presents them. Well, they had already seated him. He was already seated in the Senate. So to expel, you're going to need a supermajority vote. They didn't have it. So they just said, well, we'll take our simple majority here and just consider you out. And so that gets the 14th Amendment. You remove his opposition through this rump Senate. And insofar as Congress, the House or the Senate, they can only judge essentially the age requirement, the habitation requirement, these clear constitutional requirements set forth in the document. Stockton didn't violate any of those. Neither did any of the Southern senators that came and were rejected. So I argue that you cannot even argue that this was properly framed and cleared the houses of Congress to be presented to the states.
And notice, I want everybody to remember, you said senator from New Jersey. We're not talking about a Southern senator. We're talking about a senator from New Jersey, because it was not just the people in the South that opposed the amendment and opposed the way it was being done. I think, was it Seward who was I think Seward, but I could be wrong.
Secretary of State.
Secretary of State, who made remarks that, this is probably not constitutional. And if I'm not mistaken, the House was upset about that, and they wrote some resolution trying to justify it. But, even he recognized that it was not being done right. And, of course, there was the whole question of, and my family is from West Virginia. We are from the unconstitutionally created state of West Virginia. It was made illegally out of Virginia.
That's right. And my argument that it wasn't properly ratified, for example, it just assumes that West Virginia is properly a state. But you're right. If you look at the details of the matter, while Lincoln was fighting a war to
against secession,
end the idea, right, he essentially accepts the secession of one part of a state and makes it another state without the consent of Virginia, which, really? That's, you talk about something that's just, you look at, you just have to scratch your head. How could you do that in good faith?
Yeah. And he was questioned. There's people in his administration who tried to tell him, look, this is just not right. There's no way that this is constitutional. But in any case, it was obviously not done correctly, not done constitutionally, but that didn't stop it from being put into effect. But let's talk a little bit about the initial intent and effect of it versus what we ended up with later and what we have now.
The initial intent of the 14th Amendment, and most people will agree, at least your more radical scholars will say, well, that's only part of it. But the main intent that I argue was this constitutionalizes the Civil Rights Act of 1866, which Congress passed to try to ameliorate the lot of the freedmen in the South. They were faced with, unfortunately, black codes where, black folks without travel papers could be arrested. If a black man didn't have a job, he could be considered a vagabond and imprisoned. Many things that just made life harsh, difficult for the freedmen. And the Civil Rights Act sought to change this, to give them access to the courts, to make contracts, to testify, to sit on juries, inherit, have the same rights as white citizens there. And that was the intent, because Congress relied on the 13th Amendment to do this. But the 13th Amendment essentially just abolishes slavery. And President Johnson and a number of Republicans argued that there's just not authority to do this. So to protect the Civil Rights Act of 1866, we have the 14th Amendment, which was meant to constitutionalize that. And if we could stop there and agree just to the proposition that blacks and whites should be treated equally as individuals made in the image of God with inherent dignity, having the same rights, again, to go to court, to make contracts, to those fundamental liberties that are necessary to live in a republic, as outlined comprehensively in the Civil Rights Act, we would be fine.
Basically, make Article 4 apply to them, just like it applied to white citizens.
To make this we're equals under the law, that the law could know no color, right. That we're citizens, we're not blacks, we're not whites, we're not first class, we're not second class, we're all in it together. That's a noble aim, but we have strayed so far from that, where the 14th Amendment is now used, for example, to discriminate in college admissions. So the Supreme Court has recently tried to undo some of this. Government contracts, though the Trump administration has revoked an executive order that allowed that affirmative action, or really just discrimination. So the 14th Amendment's been twisted from making us equals under the law to, again, going back to a form of discrimination.
Yeah. But when this was first passed in 1868, they had some Supreme Court cases, I think, later that year. And I know most of the time you hear about the Slaughterhouse case in 1873, but in your article you mentioned another case that was earlier. I want to say the Twining case. I can't remember the name of the case. Twitchell. And let's talk about that a little bit and what the court said, which is essentially the same thing they said in the Slaughterhouse case.
Yeah, well, this goes to the idea of incorporation. And of course, when we talk about incorporation, we mean that the Bill of Rights is applied to the states just like it is the federal government. We know from our history, from what we talked about in Crossroads, that the Bill of Rights was meant to limit the federal government. That's what the preamble of the document said. Even John Marshall, and his opinion in Barron versus Baltimore, which I believe was 1833, took the position when someone tried to argue that the Fifth Amendment applied in a takings case. Marshall just looks at them like they're crazy and said, anybody who was alive at that time knows that these amendments were meant to provide security against an overarching federal government. It doesn't apply to states. So that's the state of the law going into the war and afterwards. And anyway, in the Twitchell case, essentially you have a complaint against the state of Pennsylvania that a charging document, an indictment, or an information, I forget which, was not specific enough in outlining how the defendant allegedly caused harm to his victim. And he brings claims, I believe, on the Fifth and Sixth Amendments of the U.S. Constitution. Well, the Supreme Court just waves those off, and you just like Marshall, Bill of Rights doesn't apply to states. What are you talking about here? No. And this is right after the amendment had been ratified. You've got, again, this is a Republican Supreme Court. Don't imagine that they're Democratic holdovers from the Taney Court there. These are solid Republicans. And they sit in Washington, where you've had these debates on the 14th Amendment. And surely, if they thought that the 14th Amendment applied, or the 14th Amendment incorporated the Bill of Rights, they would have made some mention of it in their opinion, but nobody did. So that's, again, further evidence that the 14th Amendment did not incorporate the Bill of Rights. And, to be fair to the opposing side here, though they're never fair to us, you can go to the debates in Congress and you can find remarks from John Bingham and Senator Howard that they argue that that the 14th Amendment will apply the Bill of Rights against the states in a couple of instances. So there's not zero evidence for that proposition. What I argue is the weight of the evidence is against that, because you also have Republican representations in these same debates when asked, well, is this going to change the way we do business in New York? And they're assured, no, it's not going to change as long as New York continues with its great path of liberty that it has been on since the beginning of the Republic. This will not affect any of New York's laws there. This is solely meant to counter what's going on down south. I mean, that's the representation they made. Right. Whereas if the Bill of Rights applies to the states, within New York and every other northern state, they need to change their practices because, for example, not all of them were using grand juries, which is required under the Bill of Rights to get a felony indictment. Not all of them were using juries. Like, for example, Seventh Amendment for civil cases, $20. You have to have a case tried by a jury, right? And a matter that exceeds $20. There's a number of other procedural things that this would have upended practice in state systems, but you don't see some great state constitutional revivals where they're, all right, we have to change the way we were doing business now because these amendments, these criminal law amendments in the Bill of Rights apply to us. They didn't do that. And what's more telling, you don't have the opponents of the 14th Amendment saying, if you adopt this and the Bill of Rights is incorporated, it's going to upend the way you're doing business. You're going to have to change your... Nobody argued that because, frankly, nobody really believed that these remarks from a couple of representative and a senator accurately summed up what the 14th Amendment was intended to do there. So I think the greater weight of the evidence is against just saying, well, Bingham said this. Well, Bingham said a lot of things that didn't come to fruition and didn't accord with the amendment.
Well, and if it was supposed to nationalize or federalize the Bill of Rights, I don't think most of the Union states at the time would have been for that. I mean, and like you say, there would be more records of debates. Well, do we want the federal? Because just because they supported keeping the Union together and didn't agree with the South leaving doesn't mean that they wanted the federal government to dictate everything to them. And I think
that's absolutely right.
You would have more of a record of, okay, do we really want? And matter of fact, a lot of them were mad at the Taney court. It hadn't been that long since Taney's Dred Scott decision. So they didn't have a very high opinion of the court at the time. So I have a hard time believing that they would, let's give the federal court more power. That doesn't make a lot of sense to me. I've got a question here, and let me see. I think this is one from somebody in the chat room. I want to know if you could talk to the Senate debate of 1866 where they thoroughly discussed the proposed 14th Amendment. You may not have enough time to cover all that, but if there's something from the debate over the Civil Rights Act of 1866 in the Senate debate that you want to address, then feel free.
No, I mean, I just reiterate what we talked about earlier is it was expressed over and over by members in Congress that we need this amendment, that this is going to prevent, if the Democrats ever come to power again, they cannot just repeal they can repeal the Civil Rights Act, but if it's constitutionalized via the 14th Amendment, they can't just undo it. And I think that might be what our listener is getting at. And that was, again, a main purpose of the 14th Amendment. Again, and the Civil Rights Act, a noble provision that we can support, but what court has done with the 14th Amendment since, it's hard to support.
Yeah. So it was from 1868. It's really, as far as the whole incorporation, the idea of incorporating the Bill of Rights against the states, which, in my opinion, turns the whole thing on its head. It's 1925 before the Supreme Court introduces the idea of incorporating one of the Bill of Rights against the states, and that was, I can't recall the name of the case, but I'm sure you do. So let's start there.
Yeah, it was the Gitlow case. And again, prior to 1925, there had been numerous chances for the Supreme Court to declare that the 14th Amendment incorporated the Bill of Rights. Now, there was a time or two when you had one or two dissenters that believed, well, yes, the Bill of Rights should be applied against the states, but nothing anywhere near getting a court majority, even sniffing a majority. Again, the standard accepted view was that the 14th Amendment was limited in its purpose to ameliorate the lot of the freedmen who were getting a very raw deal from the Southern legislatures, and we can protect these fundamental rights as outlined in the Civil Rights Act so they can be full citizens there. That was the accepted interpretation. Again, you have a couple of dissenters here and there, but nothing near a majority of the court, until you hit 1925 and you have the Gitlow case, and then you get a little bit of momentum, and then with the Adamson case, where Hugo Black launches really a full assault on the idea of limitations of the 14th Amendment. Black comes up with this idea of total incorporation, looking at the remarks of Howard and Bingham and some other things. But he is quickly assailed from the Academy that he is selectively picked quotes rather than looked at the full context, and you have several scholars really demolish Black's research there. And I guess you could say they succeeded in one way, is we've never adopted a total incorporation. Black would say every provision of the first 8 amendments applies to the states, period. Where we have instead had this selective incorporation, where I think the most recent was probably 2016. I think the court incorporated the 8th Amendment's prohibition on punitive fines, and that's the most recent incorporation. Of course, right before that was the Second Amendment, which the Heller case, McDonald versus Chicago, that garnered national attention in the early 2000s there. So we've never had Black's total incorporation, but we do have this selective picking and choosing, where the court essentially decides if a provision of the Bill of Rights is necessary to ordered liberty and rooted in the history and traditions of the United States, then they will say it's incorporated. They also use that test for unenumerated rights when they want to. Sometimes they'll ignore the test that they've set out and just do what they think is the right thing, which is, again, when you get to the marriage case, Oberfell, which said that the traditional definition of marriage is unconstitutional. under the 14th Amendment. You couldn't say that gay marriage was deeply rooted in the nation's history and traditions, and I dare say it's not necessary to a scheme of ordered liberty either. But they sort of punted the test and just said, "But yeah, this feels right. This has got to." This is America. This is what we're going to do. So, again, another example of how the court uses the 14th Amendment to make policy now.
Two quick things on that before I forget. We said that the court never indicated prior to 1925, and of course it got worse after that under Black and then the Warren Court. But the fifth clause of the 14th Amendment says that Congress shall have power to make legislation. Essentially, if the states are violating these provisions, that Congress would have the power to make laws to enforce those provisions. Well, it seems strange to me that from 1868 until 1925, Congress never passed any laws that said states that the Bill of Rights now apply to the states. They wouldn't have left it just to the courts. Everything else in the Constitution has law that goes with it, has statutes that go with it. So wouldn't that have had statutes created to go along with it if that was going to be the case?
Perfect. Congress knew how to exercise, its enforcement power and legislation, and we can see Congress enacting legislation like with the Ku Klux Klan Act and other civil rights bills and measures. And of course, we can talk about civil rights cases where the court, I think, properly indicates that Congress can only limit state action because the 14th Amendment prohibits states from acting, not necessarily private individuals. But yeah, Congress knows how to exercise its powers. And you brought this up earlier. The view of the court was not real high in 1868. You pointed out, and you're correct, that a primary purpose of the 14th Amendment, and this was in the Civil Rights Act as well, was to establish citizenship for the freed blacks, because under Dred Scott, and a lot of people like to beat up on Taney for this, but he didn't come up with the idea that African slaves were not and could not be citizens. There were numerous attorney general's opinions and others that held that view. Again, whether it was right or wrong, just saying Taney didn't come up with it. But one of the purposes in the Civil Rights Act and then the 14th Amendment is to overturn this view of citizenship announced most famously in Dred Scott. So Congress is not a huge fan of the court at that time. And the idea that Congress intended to empower the court via the 14th Amendment is just bizarre. Congress meant to empower itself with Section 5, not the court.
Yeah. And I think Raul Berger, and I know you mentioned him in your article, he did a lot of research on the 39th Congress and pointed out how, we are way off base here. There's no way that 39th Congress intended the 14th Amendment to do all we're claiming it does.
Raul Berger, his Government by Judiciary, and he's got another book just solely on the 14th Amendment. Though modern originalists will criticize him as a proto-originalist, that his theory is not as pure as theirs. You read it, the common man can read his book, read the arguments, look at the evidence, and make an informed decision. Berger was a great trendsetter in this, and I'd recommend his book to anyone that's interested in the topic.
And he was not a conservative, so he wasn't coming at it from a conservative perspective. He was just honest. He was a
legal scholar, just looking for the truth.
Yeah, absolutely. I think everybody should read that book as well. I've talked about it on the show a couple of times, and hey, if he's around, if he were still around, I'd love to have him on the show. But so we get to the black court, and I do have a question though. How, if black felt like it incorporated, how could it have been? How could the first 8 not have been incorporated? Where would he come up? Where would there be this idea of selective incorporation that the court followed? Because they either intended it or they didn't. We know they didn't, but I don't understand how there was an idea of selective incorporation. To me, that just tells you right there that the court is picking and choosing. And if you look, it was 2010 before they finally incorporated the Second Amendment.
Oh, that's right. What you have is essentially, in a way, you have to be sympathetic to Black, because Black, especially in his latter years, though let's face it, he was a New Dealer, a Franklin Roosevelt appointment to the Supreme Court. But it did trouble him to see judges just kind of making it up as they went in many cases. And with the 14th Amendment, the court, you have this, well, if it shocks the conscience, then we can prohibit the states from doing it if there's no clear constitutional provision, or if it's intrinsic to the notion of liberty, that right can be applied. These just loose, vague, and Berger, or Hugo Black rather, at least with total incorporation, said, no, let's stop picking and choosing our favorite rights and just apply the whole shebang. And he at least came up with a coherent argument for that, though I believe it was the weight of the evidence is against him. But at least he, in a way, was trying to limit the court in that regard.
Yeah. I do have a question from the chat room in reference to birthright citizenship. I don't want to hit that one just yet. I want to go with that last. But so the 14th has passed. It's been used and abused. I think it's destroying the Constitution. I think if we continue to follow this interpretation, things will just get worse and worse. And in your article, you mentioned that there's no saving it through interpretation. I mean, you mentioned Clarence Thomas agrees with using the 14th Amendment the way it's been used, although he doesn't necessarily mean he would come to the same conclusion on a lot of the opinions. But so what do we do? How do you think we get out from underneath the 14th? I can't see it actually being repealed.
No, here's where I come from on this is I truly believe that if we're all going to get along in the United States of America, not be at each other's throat constantly, we have to embrace a federal system. You have to let California be California, as much as I might think they're misguided, and let South Carolina be South Carolina. Let South Carolina decide what abortion laws are appropriate for it. California, if it's abortion on demand, then that's a California thing. The Constitution doesn't speak to that issue. Same thing with whether it be transgender sports, boys claiming to be girls and winning wrestling championships and swimming championships and women's sports. Again, if California thinks if they want to say they're a man, that's all you need is them to say that, then that's their business to wreck their women's collegiate sports or high school sports. South Carolina can, recognize the role of men and women as outlined biblically. And there's just a number of things that we can look at that divide us, where we're constantly at each other's throat. And it's a big fight because we're fighting for a national one-size-fits-all solution rather than recognizing, hey, maybe there could be 50 answers to this question, or some other number that are reasonable based on the history of a state, the character of its people, local circumstances, etc. Learn just to live and let live there. I really don't think we can stay together and have peace unless we can embrace federalism, which was the founders' design. So after that little monologue, to answer your question, if the 14th Amendment, as you said, if you just because you tell a lie long enough or multiple times, it doesn't make it true. Dave, no truer words ever spoken. And we have a case where we have an amendment that probably, I think it wasn't properly proposed and definitely wasn't constitutionally ratified. So what do? We sit here and we quit saying, look at the emperor, look at that beautiful robe the 14th Amendment wears, look at its colors. No, we say the emperor has no clothes. This act is ultra vires. And if enough people say that, if enough people buy into the truth, then perhaps we can just treat the 14th Amendment as a byword to the Constitution, like the old 3/5 clause. Is that something that's going to happen tomorrow? No. Is it something that has not been really discussed? No, it hasn't. But it's about time, because we live in such an age of judicial and federal tyranny in the United States, that and with the 14th Amendment as the vehicle, it's the main canon. We need to plug that canon, especially since the canon was not properly acquired.
That's a good analogy. I like that. So let me ask this. I mean, I'm going to assume that just like me, you're probably in the minority on this position, but are maybe there's some more people in, are there more judges and lawyers that think like you on this that we just don't know about? I'm not asking for names, but is it as bleak as I expect it is right now?
It's bleak, but there are a number of honest scholars that will admit, that the 14th Amendment was not properly ratified. But usually the argument is, so what? History has accepted it. Sort of like Madison and the Second Bank of the United States. Though Madison argued that the First Bank of the United States was unconstitutional, in his administration he signs off on the second, arguing, well, the American people since then have accepted the bank, and therefore they've constitutionalized it, even though the document and Madison's proper earlier arguments prohibited it. So I guess that would be the argument most would make for the 14th Amendment. But I go back to you, and a lie is still a lie, no matter how many times you tell it.
Well, if it's been that way for so long. I don't know why why didn't that apply to the marriage argument? Well, yeah, okay. So if you believe technically that it violated the 14th, well, we'd only been doing marriage for like 5,000 years. I think that maybe we should have just stuck with it.
That's right. For millennia.
Yeah.
We're crazy.
And I can't imagine that the founders ever thought that there would be governors of states and legislatures in states that were such culls, so weak, that they would tolerate that. But, we tolerated that in 2015, and look where we are now. Look at the garbage we're putting up with now. And, oh, by the way, back to the point of, well, okay, the 14th, if we don't do something, what's next? I mean,
one of and the article that you mentioned, it was originally published in Chronicles magazine. It's at the Independent Institute as well. One of the things that prompted me was a case in front of the Supreme Court where I believe it was Tennessee.
It was, yes.
Essentially passed a public health measure to prevent physicians from mutilating children. Again, young people who can't appreciate what these surgical procedures to make a girl a boy or a boy a girl means for their entire life, and a reasonable public health measure to prohibit this Frankenstein medicine. The fact that that case could get an argument at the Supreme Court, and you've got several justices essentially arguing that Tennessee's health measure protecting children is nefarious and should be compared to Loving versus Virginia and Virginia statutory law, prohibiting blacks and whites from marrying. That we're talking the same thing, apples and apples. That's when I finally was prompted to write the article that had been bouncing around in my head, that if this is the world we're living in via the 14th Amendment, we have gone through the looking glass, and it's time just to abandon the charade that we can interpret this thing in any true original sense or give it any respect. We need to treat it ultra vires.
Yeah. And the fact that so many people accept that the federal government, any federal law is supreme to any state law, and that the Supreme Court is the final word on anything. I mean, that's just totally destroying our country, in my opinion, along with the perverted interpretation of the 14th. You know, the funny thing about that Tennessee case, our AG, now, of course, our AG brought that case. Kudos to him, and the guy that argued it in court did a really good job. I don't remember his name. But, you know, that same AG, when we presented our nullification bill that we had last session, you know, he was asked to write an opinion about it. And, of course, he just gave the typical party line. Hey, you know, the bill's, you know, what did he say? Constitutionally infirm, you know, because essentially federal law trumps state law, and the Supreme Court is the final arbiter in all cases. And that mentality is killing us. That, along with the 14th, are killing us.
No, we need to rediscover departmentalism as Jefferson articulated it. We need, your AG needs to be able, and again, it's not his fault, I shall say, and maybe I'm giving him too much credit, but if you look at how law schools teach constitutional law today, there's no distinction made between judicial review, which is an appropriate doctrine,
right,
and judicial supremacy, that the court is the final arbiter on the Constitution. He doesn't know any better. If you study, as you have, Dave, and many of your listeners, you know better. You've read Jefferson. You've read the Kentucky and Virginia resolutions. You've read Madison's report of 1800. You've read Calhoun's exposition and protest. You've read perhaps Abel Upsher's volume on the Constitution. You see that this was not some just crazy theory of state sovereignty trapped up by slaveholders. That this is frankly, it goes back to Jefferson's summary view of the rights of British North America and the American Revolution, where Jefferson is arguing for the nullification of acts of Parliament. This is pure American doctrine.
Yep, absolutely. I mean, there's the revolution started with nullification. I mean, I don't understand how people can't see that was all, you know, that was one of the tactics that we used in the revolution, was to attempt to nullify the edicts coming out of England.
Yep, they believe it's only a tax protest, that our pennies were pinched, and we wanted just a tax rebellion. Nothing about sovereignty, nothing about self-government. We just don't get it.
No. Okay, so do you have time to take a birthright question from the 14th? You know,
sure.
What's your opinion of the birthright clause in the 14th?
Well, I think people forget the whole clause. They talk about birth. Birth. It says birth. But it also says subject to the jurisdiction of the United States. Yep. And that has to mean something. And it's not just a throwaway that, well, if you're here, you're obviously subject to the territorial jurisdiction of the... No, if you go back and you look at Blackstone's commentaries, you look at how these framers of the 14th Amendment would have understood and did understand that, it goes to the doctrine of allegiance. Right. That you have to have this idea of allegiance to the country. So there's a great question that if you are the child of, say, two, Mexican nationals, that you might have been born here, you meet prong one, but it's very questionable that since your parents' allegiance is to Mexico, in our example, that your allegiance would not be the same as your parents there. You know, we have Supreme Court cases, early Supreme Court cases, clearly making this distinction. And I'll tell you, there's never been a Supreme Court case that says, hey, if you're just born here, it's all good. You're a citizen, you satisfy the clause in Article 1. That has never been the case. Now, am I afraid that you take Sotomayor and her crew, and who knows what Roberts and Jackson or Amy Coney Barrett will do, that we could see some sort of feel-good Lincolnian beating the drums of a second American founding and get a bad decision. Yeah, that would be very possible, but not if they really look at the doctrine of allegiance in the common law as the founders, or the framers rather, the 14th Amendment would have understood it, just like the founders of the American Republic would have understood it. It's this idea of allegiance. And if you're born to parents that have allegiance to a foreign state because of their subjects or citizens of that state, they've not renounced their citizenship, not sought American citizenship, then their child should in no way be subject, politically speaking, to the jurisdiction of the United States, because the child doesn't, as with the parents, does not owe our government its allegiance. So that's the short answer to that question.
Okay. Kind of a wild card question here, if you're okay with it, and then we'll close. But Trump's use of the Alien Enemies Act. What do you think of how that's being, what are your thoughts on that? Is it being legitimately used, or is it illegitimate? Any thoughts?
Well, actually the Alien Enemies Act was a Jeffersonian Republican measure, because the Federalists, who had power at the time, went so far in the Alien Friends Act, which really gave the president a lot of unilateral authority. The Republicans came up with what they thought would be a wartime measure that would, if there was a state of war, could be properly used under those circumstances. Obviously, the big question we have, and of course Congress doesn't declare war anymore. World War II was the last declared war, though I think you could relate to your listeners your personal experience being deployed and in the military with under the authorizations of use of military force, which is essentially what Congress gives to the executive these days. Is it contingent upon a declared war? The Alien Enemies Act, especially in a country that doesn't really declare war anymore. It's an interesting constitutional question. I do think the statute is constitutional. It was written again in the early republic by the Jeffersonians, recognizing that in extreme cases you have to be able to deal with invaders, and just is it a reasonable argument the president makes that these gangs and transnational organizations, though not states, are essentially waging a war on us? And I think reasonable folks can disagree on that.
Yeah. Well, and if they're not citizens, I don't really see. I mean, if we know for a fact that they're not a citizen, I personally am like, okay, then get them out of here. That's just my 2 cents on that. But hey, thanks for coming on the show, and thanks for all you do. I really enjoyed it. I'd love to have you back.
Dave, I had a good time with you, and I can't wait to do it again if you'll give me a chance.
Absolutely. I want to thank the audience for taking the time to watch our program tonight. Please be sure to hit the like and subscribe buttons, as well as the notification bell, so you never miss an episode. We appreciate your support. Check out our audio podcasts on iHeartRadio, Spotify, and other platforms as well. Sign up for our weekly newsletter at our website, teeninformer.com. Please find and follow us on Twitter and Facebook. Our guest next week will be Richard Archie with the Tennessee Firearms Association to give us a rundown of the dirty dealing by the legislature on gun legislation. Is it possible that Tennessee is actually anti-Second Amendment? And then our second show, we will have a second show next week at 8:30. Will be with Chris Morris from the SEC, here to discuss the reptiles and reprobates in our GOP supermajority. Hope you can join us again next week. That's it for now. Good night from Paris, Tennessee, that is.